Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
How about this week we talk about a couple of things? Want to talk about Caremark?
We'll talk about Caremark.
Caremark claims by shareholders.
By shareholders.
Learn about that.
And we'll talk about Broadridge. Broadridge, the mysterious company that companies and activists deal with each year for sending mail to shareholders.
And probably doing some other stuff with shareholders. Yeah. But Broadridge will be kind of fun. So, all right, let's kick this off with a little bit of discussion of Caremark and what that is, or really, I mean, Caremark's a company, but we're really interested in the Caremark doctrine.
Yes.
So let's ask about what is the Caremark doctrine.
Okay, well, it's called Caremark because one of the early cases involved the Caremark company, so it was the defendant, and so that's where the name comes from. But as a doctrine, as a legal doctrine, it refers to the idea that corporations have to comply with the law. Now, I mean, that seems obvious. Of course they have to comply with the law. Everybody has to comply with the law, except maybe the president, I don't know. But everybody else has to comply with the law.
I think there is some compliance with the law, but what that means is potentially a little vague these days. But anyway, let's talk about corporations, not presidents.
So corporations have to comply with the law, but Caremark is the sort of somewhat counterintuitive idea that there's an obligation for corporations to obey the law that originates in corporate law, that corporate law, the state of incorporation law, Delaware law, obligates corporate managers to run the company in a manner that complies with the law. So if I'm the federal government and I pass a law about environmental compliance, of course, federal law requires corporations to comply with it. Caremark is the rule that Delaware law, the state of incorporation, makes it a matter of fiduciary obligation for corporate directors and officers to comply with that federal law.
Interesting. Okay, so this is sort of an intersection of corporate law, which is the main theme, or one of the themes of our podcast, and criminal law.
Well, criminal and even civil in Delaware. It's a little bit unclear outside of Delaware, but in Delaware, it doesn't even matter if it's criminal or civil. That Delaware corporate law requires directors to comply with the laws that are imposed in the jurisdictions where they operate.
And the nature of that requirement is it creates a duty, a fiduciary duty.
Exactly, it creates a fiduciary duty.
So there's not just a duty of care and loyalty, which are the two duties that I get schooled on when I'm on a board.
Well, it is part of it's considered an aspect of the duty of loyalty.
Interesting. Yeah. Okay.
Yeah.
All right. Okay. So keep going. So that's sort of the high level.
Yeah, and exactly as your instinct was that it's outside the duty of care and loyalty, and that makes perfect sense because when we come back to this shareholder primacy concept that animates so many of our conversations, it's weird because a lot of the time, obviously it might actually benefit shareholders if a company breaks the law. I'd argue it often benefits shareholders. Right. I mean, if the penalties are mild or there's little chance of being caught or you can delay investigations for years, all of which is often true when we're talking about big companies, then it may actually be more profitable to break the law than to comply with it. And ultimately, especially in Delaware, the overarching command to corporate managers is they should maximize profits for shareholders. So there's a tension between saying managers have this Delaware imposed duty to comply with the law and it's disloyal to not comply with the law, and also saying that they should maximize shareholder profit. Oh,
so you get into something I'm very familiar with and do all the time, this cost-benefit analysis, but it's around whether to comply with a law.
Yeah, but you're not allowed to do that. You are not allowed to make this cost-benefit analysis.
Oh, wow. All right, keep going.
Well, certainly you would imagine, it's fairly obvious that sometimes the cost-benefit analysis would suggest that you should comply with the law, that if there are really huge penalties that are going to really hurt the company, then obviously legal compliance is better for shareholders, and which is actually the most confusing thing about Caremark, because what makes it sort of catnip for law professors is it's not actually one doctrine, it's a couple of different doctrines. So one doctrine, one aspect of Caremark essentially fits very well with shareholder primacy, and this is the idea, what the court actually held in the original Caremark decision, that breaking the law may result in huge penalties to the corporation, Therefore, a prudent corporate director will act to ensure legal compliance just to stave off those kinds of penalties. And if a director isn't paying attention to legal compliance, if they're just asleep at the wheel, then they're violating their fiduciary duties to advance the corporation's best interest. So that concept of Caremark, that's just shareholder primacy. It's ordinary director fiduciary duties as applied in the context of legal compliance. So what a court's
so that resolves the dilemma that way, that just says the costs are so huge, just like any other cost, we need to lower it.
Exactly. So this fits really neatly into shareholder primacy. It's not even the costs are so huge. It's simply that if you're not monitoring, you can't possibly be paying attention. Like, you can't even be doing a cost benefit analysis if you're not monitoring. So the rule is that directors have this obligation to monitor and keep a system in place, just because it could very much hurt the company and hurt shareholders if they don't comply with the law. So that's one aspect of Caremark, and it's really it fits neatly into shareholder primacy, protect the corporation. But there is another aspect to Caremark, and that's the idea that we started with, that corporations are simply not authorized to break the law. That corporations are legal creations. They're chartered by the state. The state defines their authorized sphere of behavior, and corporations are simply not chartered to break the law. So one case put it, Delaware law does not charter lawbreakers. And so any director that allows the corporation to break the law, that maybe intentionally causes lawbreaking or ignores signs of lawbreaking, that director is also violating their fiduciary duties. So this idea that corporations are not permitted as a condition of their existence to break the law, that's not about shareholder primacy. That idea says corporations may not break the law even if it would be profitable for shareholders. They're not allowed to rationally calculate, given the cost-benefit analysis, it's actually more profitable to break the law. So that conception of Caremark is really the outer limit of shareholder primacy.
So kind of by virtue of, we'll use Delaware, our favorite domicile.
Yeah.
So by virtue, and because Caremark was in Delaware.
Yeah.
So by virtue of Delaware bestowing on this business organization a certificate of incorporation, just the very act
exactly
of constituting a corporation, this corporation at the time was Caremark. Mm-hmm. One of the conditions of that is you cannot ever break any law anytime for whatever reason. I don't care what your cost benefit analysis
Yeah, exactly.
says.
Certainly not intentionally. I mean,
they
recognize that, or at the director level, they recognize that a big company, stuff happens, but certainly you cannot intentionally break the law.
Right. All right. So, and this is a little weird in some way.
Yeah. Well, I mean, simply because of this tension between the shareholder primacy version, which is simply watch out for big penalties that could destroy the company, versus the non-shareholder primacy version. So there are these problems recently. So, it's been a big mess recently. Things really heated up. In a case called Marchand versus Barnhill, which is a few years ago and involved a listeria outbreak at Bluebell Creameries because the company had completely failed to comply with FDA rules, and it was eventually
an ice cream company.
The ice cream company. It was actually it was charged criminally. People died, and so of course this is an offense against shareholders. So the Delaware Supreme Court said that there are in this case, the Delaware Supreme Court said there are certain kinds of compliance issues like food safety at an ice cream company that are so fundamental, they're mission critical, in the court's words, that the board has to regularly monitor their compliance system and get updates. It can't simply delegate that to corporate officers. It's not really clear how much this decision really was a huge break with the prior case law, but it's been interpreted that way to suggest that for mission critical risks that are fundamental to the company, like the doors on Boeing airplanes, the board has the board has this enhanced duty to regularly monitor for legal violations and oversee remedial efforts. So the Marchand case really encouraged a lot more Caremark litigation whenever there's any kind of corporate scandal or news of law breaking. Now, these Caremark claims are being filed in Delaware. And honestly, I'll go further. I'll say my own sense is actually, it used to be whenever there were reports of law breaking, the first instinct for a plaintiff attorney was to sue for securities fraud under federal law. But those cases are getting harder and harder to bring. The security, like you lied, you said you comply with the law.
And those are disclosure-related.
Those are disclosure-related cases, but they're harder and harder to bring. Courts are more and more hostile to those kinds of cases, and the doctrines are narrowing that would allow you to bring those cases. So when Delaware seemed to open the door for expanded liability for law breaking, I think that kind of encouraged a shift in attention from the plaintiff's bar far. And so plaintiffs' attorneys have not only been filing the lawsuits, what they've actually been doing is inundating corporations with these 220 requests, the inspection requests, for internal corporate documents so they can investigate the law breaking and potentially bring a claim. And by all accounts, this has become really burdensome, both for the companies and for the Delaware courts that have to adjudicate all of these disputes over document access.
All right.
So
go ahead.
You might reasonably say, I might reasonably say, good, yay, good, it's good. If corporations break the law, they should get sued. Boards should be liable.
They need to be held to account for this kind of
stuff. I mean, I'm not really crying if Boeing's directors are held liable for the doors blowing up there. I mean, I don't disagree with that. It's just, for the first type of Caremark claim that directors harmed the company, that makes perfect sense for shareholders to bring a claim if they harm the company because they weren't paying attention. But the second claim, that directors took profit-maximizing but illegal action, that's a weird claim for shareholders to bring because they aren't really the ones who are injured. All this was done for their
they're
benefit.
Benefiting from the profit maximization.
Exactly. So even if the company had to pay a fine, there's a real chance that the law breaking was profitable on the whole, but the shareholders get to sue about it anyway. And that's a really difficult position.
And these are
shareholder
These are all
shareholder suits. These are shareholder derivative fiduciary suits. And it's a really difficult position for Delaware to be in because Delaware's whole thing is wealth maximization. So companies can incorporate anywhere they want to. The theory is they choose Delaware because Delaware's rules maximize shareholder wealth. That's why investors have confidence in Delaware. That's why managers tolerate Delaware. But when Delaware acts like a regulator, when it imposes restrictions on companies that are not for shareholders' benefit, that's when there's this risk corporations start moving elsewhere. And I at least get the sense, I mean, we've talked about this before, that this explosion in Caremark litigation, or even just the 220 demands, that's part of what's straining the relationship right now between Delaware and corporate boards and starting to make companies starting to think about other options.
Or at least question whether it makes sense.
Exactly.
Not just from the perspective we talked about, in past shows, but this one is related to how our board is going to be held liable for law breaking. For law breaking that,
exactly, that benefits shareholders, that possibly was intended to benefit shareholders. And it's also difficult because in some cases we know the company broke the law. So Boeing was criminally prosecuted for, the MAX
737 MAX, right?
Right. It was criminally prosecuted, so of course it was the subject of a Caremark derivative claim. But sometimes Delaware gets to the case even when there hasn't been any adjudication of law breaking. Like right now, there's this Caremark claim against Fox News. And the allegation is that Fox defamed Dominion voting systems. Fox broke the law
in the election.
2020 election. Exactly,
right, okay.
That Fox broke the law by defaming Dominion and saying that all its voting machines were rigged, and it ultimately cost Fox hundreds of millions of dollars in that settlement with Dominion. But that cost, the hundreds of millions of dollars that Fox had to pay, that was because it settled the claims with Dominion. No court ever found that Fox defamed Dominion. I mean, there was a summary judgment opinion, some elements were found, but it didn't go all the way to trial. So now Fox News shareholders, they're suing Fox News in Delaware. And that means that a Delaware court will, in the first instance, have to decide whether there was defamation. So what we're seeing is
and that's
Caremark,
beyond the settlement. Exactly. So
the settlement never, it wasn't, they didn't admit that they defamed Dominion. So what we're seeing...
It explicitly said, we don't admit.
Yeah, exactly. So now a Delaware court will have to kind of figure out whether there was defamation as part of this governance Caremark claim. So what we're seeing is Caremark sort of expanding Delaware's regulatory ambit. It takes Delaware out of its shareholder wealth maximization expertise, corporate governance, and folds all these other areas of law into corporate governance.
So there's all sorts of factual matters that are going to
come before
Chancery.
There was a whole big thing about AmerisourceBergen and Walmart. Did they violate the opioid laws with their opioid distribution? This is not supposed to be what Delaware does, but it has to because
this is not what Chancery, right? Exactly.
So I mean, and really, there's sort of a legitimacy thing. What right do Delaware judges get to adjudicate law breaking all over the country or potentially the world? I mean, it's not really their purview.
Okay, so wow.
And I think that's some of the mood that's animating these attacks on Delaware. These claims expand its reach. And fundamentally, I think there's a sense in some quarters, a totally reasonable sense, that corporations are engaged in too much law breaking, and the legal systems, the criminal legal system, even the civil legal systems, aren't good enough at punishing corporate crime.
To try to
so Delaware is a good place. But Delaware's not really well positioned for that. So it can only push so hard before corporations start to leave.
This is kind of a version of our friend Matt Levine at Money Stuff.
Yeah,
he is saying that everything is securities fraud.
Right, exactly.
So
but now
in
it's
Delaware
everything
Chancery,
is
everything is criminal
everything's
offense.
a Caremark. Yeah, exactly. Everything is a Caremark case, and I think it's because, to some extent, it's not. It's my sense that it's because it's not securities fraud, because the securities fraud cases have become so hard to bring.
Right. Yeah. So is just like Delaware responded to what was it, Moalis or whatever?
Yeah.
And just this past spring changed the law. I mean, the Delaware legislature stepped in to adopt some sort of, I can't remember what it's called, market practice or whatever.
Well, that was Vice Chancellor Lester called them the market practice amendment. The derision in that title is very subtle.
It's great. I know, right? It's delicious. Is there some sentiment that Delaware is going to do something similar?
Well,
with
that's sort of the
Caremark?
problem. So, I mean, Delaware's in this tough position, very much like the political problem it has with TripAdvisor and companies moving out of Delaware. How does Delaware openly say, yes, it's totally fine for our corporations, these entities that we charter? How can Delaware say these entities are permitted to break the law? I mean, how can they say, actually, if a Delaware corporation breaks the law of California, that's really California's problem. And if California doesn't like it, California should do a better job of prosecuting. I mean, as a practical matter, that really is how the system works, but it can't really be the official position of the state of Delaware that it's going to create these corporations and design their internal governance systems, but it's totally not Delaware's problem if they go out and break laws in other jurisdictions. And I think there was a time when corporations would sort of tolerate this. They would understood that political dynamic that Delaware has to put on this display. Oh, we don't tolerate law breaking. I think that they understood that was necessary because if Delaware looks like a responsible steward of its corporations, federal government doesn't intrude. It doesn't step in and say, we're going to interfere with corporate governance. So everyone was kind of happy with that arrangement. But now we're in a time when the threat that the federal government is going to meddle is pretty much off the table. I mean, it's just not going to happen, not with the Trump administration, not with, conservative courts interfering with things that the SEC does. So I think managers don't feel like they have to tolerate this. So what is Delaware to do? I think what it could do, the simplest path, might be to actually just limit books and records. Because if it cuts off that access, if it cuts off the 220, that might relieve burdens on corporations, and it cuts off the path by which these claims even establish that there's been board-level violation of the law, and so the cases can't survive. But that could have unintended consequences for other kinds of claims. So
I rely on books and record stuff for all sorts of purposes, not just because I'm thinking of suing a company.
Exactly. So it's not clear. Like, I think that doctrinally it's a difficult path to get out of, and the most obvious wiggle room is by cutting off books and records somehow or limiting the access. But of course, you go too far and you really throw off everything. So I think it's a really difficult problem for Delaware.
Wow. All right. So we'll have to. It sounds like we'll come back to this at some point. It sounds like there'll be more cases, and sometime in a few months we'll schedule another podcast to try to talk about even more recent developments. But that is fascinating. Everything, not everything is securities fraud, but everything is a Caremark case.
Exactly.
Well, let's think about that as we take a little break, maybe.
Okay.
And we'll return and we'll look at Broadridge and so forth and its complications here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFloatAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFloatAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFloatAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So we're going to talk about Broadridge. Companies encounter Broadridge every year, and activists need to deal with Broadridge with some frequency. So who is Broadridge?
Who is Broadridge? Broadridge is this ubiquitous, and to at least a lot of activists and shareholders generally, and probably to companies, this kind of lesser-known cog in the machine of corporate governance, or to use an SEC phrase, kind of like a pipe in the proxy plumbing mechanics, which is of course the metaphor that the SEC at least has adopted. It's best described as a shareholder communication company. It was originally part of ADP.
Okay.
The broad, technology company. And then they got spun off several years ago, renamed themselves. And they communicate in all sorts of ways facilitate communication between companies and shareholders and so forth in all sorts of different ways for, bonds and litigation and so forth.
So proxy materials, things like that?
Yes. We're most interested in how companies and also shareholders work with Broadridge to communicate with a company's investors, a company's shareholders.
Okay.
So essentially, it's an intermediary that, in routine matters, a company will then, send its, once a year, its proxy materials to its shareholders through Broadridge. And then when we get to someone like me, an activist, we start to need to know a little more. At least I set out to learn a little more this year about what Broadridge does. And I found the experience actually somewhat pleasant, to my surprise. But to Broadridge's, I suppose, satisfaction, it worked pretty well.
Okay.
And that's kind of what I was thinking of exploring here is how that worked and kind of what they did to make it work.
Okay. So what did you find out?
I got in touch with them, and there's actually a pretty easy way to do that. Just over email, a couple conversations, basically to learn about the shareholders of a couple portfolio companies that I was kind of following. Mm-hmm. Now it's worth noting kind of what Broadridge does, but also doesn't do. So Broadridge is not like the database or the data custodian over a company's shareholders. Broadridge, again, facilitates and sends out mail or can send out emails to a company's shareholders, but it's not like they're the year-round data set of a company's shareholders. That's going to be in various custodians' databases. So that's going to be at State Street or Schwab or something. Mm-hmm. So what happens is that when a company, in this case, one of my portfolio companies, decides to schedule an annual meeting, they'll declare a record date, which we all know about, and then Broadridge goes out and contacts a whole bunch of, as we say, custodians, usually broker-dealers, but it could be banks and so forth, and says, okay, tell me all the shareholders for this company on this date. Broadridge then compiles that information, and then we're off to the races. So Broadridge has, for like an upcoming shareholder meeting or special meeting or something, as of the record date, all that information as of that time. And so once they have that, you could do some pretty cool stuff.
And this is how they make money?
Well, yeah. So it's actually kind of interesting how they make money. Their clients are these custodians. Okay, so Schwab in particular.
So the brokerage companies.
Yeah, the brokerage companies. So Schwab has picked their, kind of servicing company to be Broadridge. Okay, so has Fidelity. Most, like 80% of the shares in the U.S. are communicated with through Broadridge. There's another firm called Mediant that has something like another 15 or so percent. Again, you don't have to pick Broadridge if you're one of the custodians. So, for example, Robinhood, the online brokerage that's popular with millennials, so to speak.
With my students.
Your students. They use a company called Say Technologies that they acquired a few years ago. So if you're me and you want to get to a company's shareholders that are held at Robinhood, I call Say.
Okay.
And I say, as of this record date, I need to get in touch with all the shareholders that are at Robinhood, and that'll get me to 2-3-4% of the shares, not many.
Right.
But if you want to do a complete job, you go to those three: Broadridge, Mediant, and then Say, and then maybe a couple others.
Okay.
But Broadridge is by far the dominant holder. But what's interesting is none of these custodians pay the fees. They just kind of pick. The people who pay the fees are companies and activists. So Broadridge has this fee schedule that is public. It's set by the stock exchanges that says, okay, if you want to contact, people for a contested solicitation for a proxy contest, it's going to cost you, it's roughly $1 or $2 per account. And, people can have multiple accounts and so forth at different custodians or whatever. But it costs, it sort of scales up, and then there's a minimum cost of $5,000 to set it up and so forth. There's a whole fee schedule that you can look at. But it's the companies and the shareholders, the activists, that pay the fees to Broadridge based on, the custodians designating them as the preferred shareholder communication provider, I guess.
Okay.
So anyway, so once I kind of look at the fee schedule and sort of figure out, oh, this is how this works, you can sort of move to the next step. So there's a couple of things that you could sort of do actually for free that I was pretty impressed by, because I like doing things for free. So there's an email you can send to at they have a special processing desk. Broadridge has that on their website, and you can request basically this key list. It's called the Share Range Report, and it shows within different ranges from over 1 million shares, how many accounts there are and how many shares they own, and between 500,000 and 1 million shares, how many accounts and how many shares they own.
I see.
And it gives you an idea of kind of the dispersion or the distribution of shares, and you figure out, okay, there's 10 really big accounts.
Yeah, so how concentrated the shareholder base is,
Exactly.
and so you can figure out, like, do I need to talk to 1,000 people or do I need to talk to 10 people?
That's precisely the problem, because sometimes and everyone used to think you had to do this like through a proxy solicitor, and it really helps. Proxy solicitors do this all the time. But if you're like an activist and and even if you're a big one and you're just kind of curious about what the shareholder list look like, and you don't want to just rely on 13F disclosures, which are late and also not always quite as accurate or whatever, or a little hard to decipher, this is a really good way to kind of sort out and figure out what a company's kind of share distribution looks like among the shareholders. And you can do all sorts of analyses here. So if you want to figure out, okay, I need to solicit 50% of the shares in order to comply with the bylaw, then you kind of know if you're going to be soliciting, as you started saying, 100 or 1,000 accounts just to comply with that.
Right.
Or if I want to solicit to 67%, because that's what it takes to comply with universal proxy, then you know how many accounts you're dealing with. And you really can kind of get, and Broadridge will even give you a budget. They'll even say, here's an estimate of what the cost is going to be based on soliciting, if you want to solicit 40, whatever. They're pretty collaborative that way. It was, like I said, it was kind of fun and pleasant to kind of learn this and not have to like go through lawyers and everyone else. So that was quite eye opening to figure this out. The thing you have to know is a record date. Okay, so here's a couple of other interesting little tidbits. Companies usually disclose the record date only after it's occurred.
So people can't buy into it. Yeah,
exactly. So you can't buy into the record date. But once you have the record date, you can say, okay, what's it look like, and you could get the that share distribution list. The other thing that Broadridge will tell you about is the famous NOBO list. Mm-hmm. And let me explain that a little bit. I'm not sure there's some people might be familiar with that. But NOBO stands for non-objecting beneficial owners. Okay? So if you, like we just talked a little while ago about books and records demands, I've done that all the time. You do a books and records demand, you ask for a shareholder list, company's going to give you the registered shareholders. So there's going to be a lot of people who have, the certificates on their wall, and that's going to be 2% of the outstanding. And like 90, some huge number is all held, basically, as we say, in street name.
In the brokerage. So your account at JP Chase, your account at State Street.
So the nominal shareholder is your custodian.
Right. So when you ask for a shareholder list, you're going to see JP Chase,
Right.
Charles
Or
Schwab, State Street.
you'll see this company called CD and Company,
yeah.
which is the nominee for
all of those,
for depository trust. Okay, which is, again, that's kind of the company that really has that list of shareholders that we were talking about a little while ago that Broadridge then obtains once they know a record date. Anyway, so when you, like you and me, when we go sign up for an account at like Schwab or Fidelity or wherever, you declare on the forms whether you consent to disclosure of your information to any company where you own shares. Okay, it's a standard part of almost all account applications. And if you consent, which, most people don't really care, you become a non-objecting beneficial owner. You don't object to the disclosure.
To giving your name to somebody who wants to know who the shareholders are, the real shareholders.
Right, exactly. And that list is really valuable, okay? Because that's what allows you to get kind of underneath that list of registered shareholders that lists, 95% of the shares being held by CD and Company. And so when I do a books and records demand, I not only request the registered shareholder list, because that's the company has to give you, I also say, give me the NOBO list, please. I want to know, the identities, of all these non-objecting beneficial owners. Okay, well, companies will say, well, I don't have it, I don't need to give it to you, or, ask me twice or something. Okay. And so, companies are not obligated to obtain the NOBO list from Broadridge, but almost all the time they do. Or their proxy solicitor for like a routine shareholder meeting will go get that NOBO list, because that's how they get in touch with all the shareholders to send them proxy stuff. Okay. Well, if you were to go to Broadridge and request that share distribution, you can also you can ask, when's the last time you sent a NOBO list to the company?
So you don't get the NOBO list. You don't get the shareholder. You can't get the NOBO list.
Broadridge cannot send the NOBO list to you. The only place you can get the NOBO list is from the company.
But Broadridge can tell you when the company asks for it, so you know what the company's up to.
Exactly. So they can say, oh, as the last record date, we sent them a NOBO list, or we sent them a week later, or whatever. Yeah. So you can say, I want the most recent, and I want the most recent NOBO list, that was from 9 months ago or something like that. Okay. Yeah. And realistically, the NOBO list doesn't change that much. Okay. Most, there would be
because there are a lot of passive holders. They're not constantly trading.
Exactly. Or if there's some really active holder, if their position changed a lot, you'll see it on their 13F or on some other filing, a 13D or G, or a 13G. Or, if they do, then, maybe they're doing some trading, but it's kind of not going to change that much. So that's the way to figure out how to get a NOBO list from a company. Broadridge will also help you with that. Mm-hmm. So that was kind of enlightening, because I always run into problems saying, give me a NOBO list, and the company says, I don't know. I don't have that.
NOBO never heard of it.
I know you do. I know Broadridge told me you requested it.
So you can ask for it specifically. Okay.
Yeah. So anyway, so that was the other way in which Broadridge was kind of helpful. And again, you can do all the same stuff with Mediant. They have the same, go to their website and they can, give you an email that you can, and you just ask them. And, they might want to say, hey, are you working on, are you a shareholder? Or are you, show me a 13D filing because you're working on an activist situation, something like that. Right. Because they're not just sent out to anybody. But it was amazingly efficient to be able to learn about this in a way that I hadn't quite expected. So so that was kind of fun. Yeah.
So. Okay. Is there anything more that?
No, I mean there's a lot more that Broadridge does. They count votes. Too.
Yeah, they count the
votes.
They
run the voting website and so forth, but that's kind of passive to an activist.
I see.
That just kind of happens and so forth, and they make a lot of money doing all sorts of other stuff. But just in terms of this kind of initial research into what a shareholder base looks like, they're invaluable. Wow. And really kind of accessible. So that was really good to know.
All right.
Yeah.
Okay. Well, then let's wrap up there, and there's more we'll cover next time.
Thanks, Ann. It's been terrific talking about all these subjects. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find Mike at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again soon.